All right, good afternoon, everyone. Thank you for attending our Lunch and Learn in our Money Matters series. This session is Family Law, Protective Orders, and Personal Property. Thank you for joining us today. We are the Maryland Coalition Against Sexual Assault, which is the federally recognized state sexual assault coalition working to end sexual violence in Maryland. And our core members are the 17 rape crisis centers and many other professionals throughout the state who work with sexual assault survivors. Today we have closed captions available at the bottom of your screen. You can pin those if needed. We also have Elijah, an ASL interpreter, with us today. Thank you so much for being here. And both Sam, our presenter, and Elijah are pinned to your screen so you can view both of those. We are using Zoom webinar today, so any communication can happen in the chat or in the Q&A. We will check that throughout to make sure we can do our best to get your questions answered. If folks want to introduce themselves in the chat, go right ahead. We are also recording this webinar today, so you'll receive that recording in a follow-up email, and we will send out more information after the session. I would now like to introduce today's presenter, Sally Staff Attorney Samantha Rogers, who will lead the webinar.
Great, thank you so much. And again, welcome everyone, good afternoon. I'll be presenting this afternoon's webinar. So this webinar is a part of the Money Matters project, which focuses on the financial impact of sexual assault and examines the economic empowerment of survivors. Sexual assault has serious financial costs to survivors, and this project aims to increase the financial stability and security of sexual assault survivors to support their recovery and prevent future violence. This goal is supported in part by educating attorneys and advocates about legal remedies available to support a survivor's financial independence. Some of our objectives for today's webinar are to learn and discuss financial issues for survivors in divorce, custody, and child support proceedings. We will be learning about financial support in protective order cases, understand the differences in use and possession of personal property and residences in family law cases versus protective order cases, and we will learn about options for survivors seeking remedies for personal property. Some of our core reminders throughout this series are that the law is always changing and to always check the law for the most up-to-date information. It is crucial to properly complete and file the proper financial statements in actions where there is a duty to support. Undocumented survivors may face restrictions, and some options may be impacted by a survivor's immigration status. Always check eligibility requirements before advising undocumented clients. Finally, tort suits may not always be an option, but when available to survivors, they can change a survivor's financial stability. Tort law has difficult statutes of limitations, and attorneys must advise survivors about available torts and statutes of limitations. First, we will be talking about family law. Financial relief for survivors varies depending on whether that survivor and the perpetrator have children in common. Divorce and custody actions are a potential avenue and can potentially address long-term financial stability. A survivor with no marriage or children in common with the perpetrator will have fewer options, and there are distinctions in relief available in custody or divorce actions and in protective orders, which we will discuss later in this webinar. First, child support. Maryland uses a formula called the Child Support Guidelines in order to calculate support. Like a tax return, there is no discretion in these guidelines. You plug numbers into a formula and get the calculated amount of support. You cannot negotiate the right of child support away because it is the right of the child to collect that support. When filing a child support case, it is crucial to file a long-form financial statement detailing the financial information of the parties. The child support guidelines are mandatory in Maryland if the parties earn a combined $30,000 a month or less. If a parent is voluntarily unemployed or underemployed, the court can impute income under the factors under the Family Law Code, Section 12-201M. To impute income simply means to attribute income to the parent for the purpose of calculating support, even though they are not actually earning that amount. Generally, the parent with primary physical custody of the child is entitled to child support. However, in cases where parties are above the guidelines, a non-custodial parent can receive child support. In order to calculate support, the court requires certain information from the parties that can be listed in the code. Financial statements provide much of this information. Make sure to not forget them and be sure that unrepresented survivors file them as well. Alimony is also called spousal support. It is court-ordered financial support paid by one ex-spouse to the other ex-spouse. It can only be awarded before a final order of divorce, and once this is waived, you cannot later make a claim asking for alimony. There are different kinds of alimony, and there are different factors the court takes into consideration when deciding whether to award alimony. Of the different kinds of alimony, first is pendente lite, which means it is awarded pending litigation. Its purpose is to maintain the status quo during the divorce, but an award of pendente lite alimony does not guarantee a later award of alimony at the conclusion of any litigation. Next, rehabilitative alimony is temporary. The purpose of this kind of alimony is for the spouse to become self-supporting. Finally, we have indefinite, which is long-term alimony, and is awarded when a recipient spouse cannot make reasonable progress towards supporting themselves, or the standards of living between the parties would be unconscionably disparate. So there would be a wide gap in the standard of living between the parties. Indefinite alimony is becoming increasingly rare. For alimony, the parties must file a long-form financial statement, and this can be amended up to 10 days before trial. The reservation of alimony can be requested, but only under rare and exceptional circumstances and under the court's discretion. So reservation of alimony would not necessarily be appropriate under vague potential future circumstances. Property. Maryland is an equitable distribution state, meaning the court will divide marital property in a way that is fair, not necessarily equal. Any property obtained during the marriage is considered marital property. However, it's important to note that separated spouses can still acquire marital property. The court considers both monetary and non-monetary contributions when making an equitable division. For personal property, the court can decide how this kind of property is divided, and when the parties have a minor child in common, the court has the power to decide whether one party has sole possession and use, or both parties are entitled to possession and use of that property. The spouse with custody of minor children can be awarded use and possession of any family use property. This is considered property such as a car, furniture, or appliances, for example. The court must consider the best interests of the child, the interest of each party to use that property, and any hardship on the other party. Any award would terminate 3 years after a divorce is finalized, and the court would divide this family use personal property at the end of this use and possession period. Family home and mortgages, the court can order that either one or both parties are responsible for paying all or part of a mortgage, any insurance, assessments, taxes, maintenance costs, or any other expenses connected to the property. And this can be ordered during the pendente lite period or during the period of temporary use and possession. The court can also award the exclusive use and possession of the family home to the spouse with custody of the minor children. Again, the court takes the same considerations into account as with personal property. They would consider the best interests of the child, the interest of each party, and the hardship imposed on the other party. This would terminate 3 years after a divorce is finalized. Monetary awards. This is a financial award given to one party after the court divides property. This purpose is to make dividing property fair for both parties by compensating the party with significantly less or no title to property. You must show that the division of property according to title would create an inequity that could be overcome with a monetary award. There are 3 steps for monetary awards. The first is to identify the marital property. Next would be to value the marital property. And finally, equitably divide the marital property. In order to determine the value of marital property, you would need the present day value of the property that is to be divided. This would not include certain retirement assets or any deferred compensation. You would have to prove that asset's value, and this can be done through a joint property statement, through testimony, and discovery responses in order to show value. If there is no evidence shown of an asset's value, then that value is considered to be $0. So it is important to be sure to give evidence of value. There are overlapping factors in the law that the court considers for both alimony and for monetary awards. One of these overlapping factors are the circumstances that contributed to the estrangement of the parties. This factor would also include facts for abuse, spousal rape, and sexual assault. Pensions and benefits can be considered marital property, but it is up to the court whether a pension is included as marital property and its value. The court can order an ownership interest or grant a monetary award for a spouse's pension. If the other party has retirement assets, be sure to ask your client about survivor benefits for those assets. The court can also order that pension or retirement be paid if it is received, as it is received, and when it is received. Additionally, spousal Social Security benefits do not require a court order. A spouse is entitled to their ex-spouse's supplemental security income benefit if the spouses have been married for at least 10 years. The ex-spouse would collect this benefit at the age of 62. If your client is close to that 10-year mark and is considering divorce, and that client knows that their spouse has supplemental security income benefits, this is an important issue to flag. Debt. The court can consider debt in proceedings. Marital debt is also a factor in any monetary award. A court can award more property to a party who has more marital debt. The court would also consider marital debt when determining the value of marital property. A spouse is not liable for debt acquired before the marriage by the other spouse. However, third-party creditors will come after one or both spouses for joint debts during the marriage. So it is important to include an indemnification clause in divorce agreements. If there is joint tax debt from the marriage, innocent spouse relief may be available as long as the reporting spouse improperly reported items on a tax return and the other spouse lacked knowledge about this improper reporting. It is good practice to request an IRS transcript of a client's tax history to determine whether there are any tax issues. Next, we will be discussing protective orders. This is an order from the court protecting a victim of abuse by ordering another person to stay away. This order lasts for 1 year and can be extended under certain circumstances. The court can also order other temporary relief, such as temporary use and possession of a home, car, or pets, or any other property, and the court can also award something called emergency family maintenance. The petitioner is the party filing for a protective order, and the respondent is the party against whom a protective order is filed. There are some issues with use and possession that I'd like to take a moment to compare. For a protective order, any use and possession of property lasts for the duration of that order. Use and possession is for any jointly owned vehicle, pets, and residence. Use and possession can apply even if the parties are unmarried with no children, if the petitioner is on the lease or deed to the home, or shared a home with the respondent for at least 90 days within 1 year before filing the petition. In divorce, use and possession always follows the children. The use and possession of the family home or any family-used personal property terminates 3 years after a grant of divorce or upon remarriage of the spouse with possession. The court can divide family use property after that 3-year period. What use and possession in both of these actions have in common is that these are always temporary awards and they do not change title to any property. Emergency family maintenance is a temporary support ordered by a court for the duration of that protective order. It is paid by the respondent to a petitioner, and in order for the court to order this maintenance, there needs to be a duty of support, so a marriage or any children in common. The courts will often consider the child support guidelines, mortgage, and other costs when awarding emergency family maintenance. If you're asking for emergency family maintenance, it's important to file a financial statement called a short form financial statement. This form would list various expenses like rent, mortgage, childcare expenses, utilities, and leaves room for other costs as well. You should come prepared with evidence of both parties' income and expenses, which can be shown through bills and pay stubs, for example. You should also be prepared to offer a reason for why you're requesting a specific amount. So for example, if you're asking for half of the mortgage, or if you're asking for child support in accordance with the guidelines. To drive home these issues, I'd like to go through a hypothetical. I will be walking this through and answering, but please feel free to put your responses in the chat as well. In this hypothetical, Dora was sexually assaulted by her partner of 3 years, Dan. Dora and Dan live together in Dan's apartment, and Dora's name is not on the lease. Dora and Dan share a car, which Dora primarily uses to get to work. Dora comes to you seeking advice on what relief she can ask for in a protective order. So first, what information would you want to collect from Dora in order to advise her? Information that I would want to collect is, are Dora and Dan married? How long have they lived together? Who has title to the car? Do they have any children in common? And ask if there's any other property that Dora is concerned about. These are some examples of information I would want to get from Dora to assess the relief she could ask for. Dora tells you she and Dan have lived together in Dan's apartment for 2 years. How would you advise her? In this situation, because they have lived together for 2 years, Dora would have grounds to ask for temporary use of the apartment on the basis that they have been together for at least 1 year and cohabited together for the last 90 days in the unit. This would give Dora grounds to ask for that temporary use of the apartment. How would your advice to Dora change if you discovered that Dora and Dan have a child in common? If there is a child in common and no marriage, that means that Dan would still have a duty to support. So Dora would be able to ask for emergency family maintenance in this situation. What would you need for a claim for emergency family maintenance? As we've discussed, Dora should fill out that short form financial statement, and she should include any costs for rent, for childcare expenses if they have a child in common, any utilities, and any other costs Dora may have that she would need help and support through an emergency family maintenance award. Finally, after a protective order hearing, Dora was awarded use of the apartment, emergency family maintenance, and use of the car. What would you advise Dora about next? The most important thing I would advise Dora about is that this is a temporary award. This will not last, and this only lasts for the duration of the protective order. For any other issues, Dora would need to file a suit in court. For example, if she needed child support for any child in common, that long-term support would not be addressed here and would go through a different action. Finally, we'll be discussing personal property issues with Replevin and Detinue actions. This is a potential avenue for survivors to get their personal property returned or its value from an abuser that refuses to return their property. And this is especially useful in cases where there is no marriage or children in common. You can ask for potential damages, which would be monetary compensation for loss, and there may be filing fees for this kind of action, but financial eligibility waivers may apply. First is Replevin, which is an an action asking for the return of personal property. This kind of action is only filed in district court. This would first require filing a request for service and a show cause order. From here, something called a show cause hearing is scheduled, and this is a temporary hearing to determine who is entitled to temporarily possess the property at issue. The party that is awarded to temporarily possess that property would also have to pay bond to ensure that that property is returned for a final hearing. The final hearing determines who owns the property, whom the property is awarded to, and any potential damages. Detinue, on the other hand, is an action that's asking for the return of personal property or for that property's value in money. This action can be filed in district court or circuit court, but depends on the value of the property. In the district court only, detinue cases where the property is valued at less than $5,000 is where someone would file this kind of action. In cases where the property is more than $30,000, a detinue action would be filed in circuit court only, and for property that is between $5,000 and $30,000, this could be filed in either district court or circuit court. And that is the conclusion of our discussion today, and I'm happy to take any questions in the chat. We have, just so everyone is aware, this is a part of a larger Money Matters series with other webinars as well. And my information is also on the screen, and I can be contacted for any other questions.
Thank you so much, Sam. If anyone has questions, we have a minute here. Feel free to put them in the chat or in the Q&A. I've also shared the link to our evaluation form. We greatly appreciate your feedback on the training. If you can fill that out for us as well, if you're looking for a certificate of attendance.
Thank you so much, everyone. And again, I am able to answer any questions you may have if you think of something later, and my contact information is on the screen. I can be reached by email.
Great. Thank you so much, everyone. Thanks for attending MCASA's training series. We hope to see you at a future training.